Welcome back to Courtroom Chronicles. Right from the start, this case drops us into the thick of it. The defendant, Miss Watkins, is standing before the court for a string of troubling probation violations. We're talking missed drug testing, multiple alcohol positives, even one inside the courthouse itself. That's right, she walked into court this morning and tested over the legal limit, while still on probation for a previous DUI crash. And as you'll hear, that crash wasn't minor. It involved a 24 BAC, nearly 3 times the limit. The stakes couldn't be higher. Every violation risks more jail time, and the judge makes it clear that patience is running thin. The defense, meanwhile, is trying to paint a sympathetic picture. A single mom with 2 jobs, struggling with anxiety and depression, who took a shot of alcohol just to calm her nerves before court. But will that explanation hold up? Stick around, because the judge's reaction to her decisions is nothing short of explosive.
You came up to the court with a .78. The day after, you just got in trouble for coming up to the court with a .05. So you literally 2 days in a row. And I don't know, I can't begin to court while on probation. I mean, it's a .7,
This
a
is a
point technical violation, so you could get up to 15 days in jail on this. Do you understand that?
Yes, ma'am.
The allegation is that you failed to appear for drug testing on January 15th, that you tested positive for alcohol this morning at the court with a .051, when you came in at 8:10, and then you had a .048 on at 8:13 a.m. Do you understand that?
Yes, ma'am.
Mr. Gazicki, how's your plan?
Those charges, Watkins going to plead guilty, and we could address the court prior to sentencing.
Okay. So, ma'am, to the allegation that you failed to appear for drug testing on January 15th, how do you plead?
Guilty.
To the allegation that you came in this morning and tested positive on a PBT at the courthouse at 8:10 a.m. with a .051, how do you plead?
Guilty.
Okay. Mr. Gazicki?
Yes, Your Honor.
I'm going to accept the pleas.
Okay. I explained to Ms. Watkins, these are serious, violations. Any violation is serious. There's a recommendation of 5 days in jail. Your Honor, I don't, personally, I don't think that's really going to do, well, let me put it this way, it's going to cause more harm than good. Ms. Watkins, for one, expressed to me just the few hours that she's been in jail today has terrified her. She never wants to be in that situation again. I understand with the other violations, she was not exposed to any kind of incarceration, let alone 5 days. At the moment right now, her main issue is she's got an 11-year-old son who to 3 o'clock. There's no other arrangements for the child to be picked up. Also, Ms. Watkins has 2 part-time jobs. She's starting another part-time job in the morning. She makes about $14 an hour. And any kind of incarceration obviously is going to have an effect on the new job that she's just starting, and possibly on the one that she has now. She's trying her best, Your Honor. She does have doctor's appointment on Monday that she reports. She has to see her psychiatrist, a psychiatrist and a counselor, I believe. Is that correct? Therapist. She has an issue of depression and anxiety. She has not had medication for those illnesses, and foolishly, she took some alcohol this morning, trying to calm her anxiety.
How'd she get to court today?
How'd you get to court today?
I drove. I live like two minutes down the street.
Your Honor, that's not a good move, but it's still not under the .08, and there's no allegation that it impaired her driving. But it's not a wise choice.
Not at all.
Okay. Your Honor, we're just asking the court if possibly the sentence could be held in abeyance. Let her see her psychiatrist and therapist on Monday and see where that plays out.
Anything else?
No, Your Honor.
All right. This is her second use violation. This is the second positive alcohol screen she's had. I thought she should be in treatment court from the get, and I can't recall what it was that led her to not be in treatment court. It might have been that she wasn't interested in the program, or the time constraints were too much, but it's certainly clear to me that she needs increased supervision because she's not doing well. I couldn't imagine getting in a drunk driving accident, getting in a car accident while drunk driving. She said a 0.2 something. It was a 0.24, 0.24, or 0.29, something very high. It was 3 times the legal limit. You got in a crash, right? Then you get put on probation. You've already been caught drinking once and admitted to it. You've had another violation for a missed test, and now here we are. It's really concerning to me, Ms. Watkins, that you would drive a motor vehicle to a court to PBT test. I mean, it's the lack of judgment is so, it's startling, to be honest with you. It's shocking to me. And it says, and I think, Ms. Watkins, you know this, you've been in front of me a few times. Have I always treated you fairly?
Yes.
Like, I'm not disrespectful to you. I'm not, you know, I have expectations, so I have court orders that you've got to follow. And I can't not impose a sanction, you know, on a violation like this. I mean, in a lot of, if it would have been your 4th violation, you probably would have just done 90 days in jail. But I'm confined by the law. I can't do that. But your next one, I can. And if it's a use violation, if you're not taking advantage of the resources that we're providing you, and you're not interested in trying to live your life in a different way that doesn't put you in front of a judge, then maybe it's best you just do your 90 and move on. We're going to extend probation 3 months. All other terms of probation will be completed. I can't see any, I think Kara's recommendation, it could have been for 15. She's only asking for 5. I am adopting the recommendation. She drove a vehicle to court with a 0.05 to see a probation officer while she's on probation for drunk driving. The recommendation of probation will be followed. She's to serve 5 days of jail forthwith.
Could she have a startup date tomorrow, Your Honor? Take arrangements for her child at school?
She can make phone calls. Okay, so the allegation is that you came in this morning and you tested positive on a PBT at the courthouse on February 24th at 10:20 a.m. With a 0.078, and then at 10:30 a.m. with a 0.076, and that you admitted to drinking the night of February 1st of 2024. How do you plead to those allegations?
Guilty.
And you understand that if you enter a plea of guilty, that you're waiving your hearing rights if I accept this plea. You understand that? There will be no hearing of any kind.
Yes.
Okay. And you still want me to accept that plea?
Yes.
And for the record, if I can order my client for.
Please.
And Ms. Watkins, now what was the last test, Judge?
10:30 a.m.
You understand, Ms. Watkins, that it's one issue, so there's a chance you would still register some alcohol in your system if you were to take another PBT test. Just based on the timing, that's a possibility. You understand that?
Mm-hmm. Is that a yes?
And you and I have had an opportunity to talk, correct?
Yes.
And were you comfortable with understanding what we discussed?
Yes.
Not necessarily what we discussed that you were comfortable with, but the fact that we communicated fine, you understood what we were talking about.
Yes.
And do you feel that you are in any way impaired by your use of alcohol yesterday?
No.
Thank you.
Okay, thank you, Mr. Fanto. And it's 1:55. I mean, if you're more comfortable, we can have a PBT.
Oh, she would be fine with the numbers, Judge.
Okay. All right. So I'm going to accept the plea as knowing and voluntarily given. Mr. Fanto, anything on behalf of your client?
Judge, I appreciate the recommendation. However, number one, I think given her lack of history, the recommendation is considerably high. I appreciate the fact that she's tested positive. She clearly needs help, and she acknowledges that. Unfortunately, it looks like we're a month or so short of being able to put her into treatment court at this point. I would ask the court to consider the intensive probation program for her after she serves her 5 days. The court always has the option of finishing any kind of jail time that it has available to it. However, I think it's more important that we look at somebody who clearly needs help, is acknowledging that she needs help. And I think that based on conversations yesterday, Ms. Grasso was setting up therapy and for that nature, that was the plan.
Yeah, she was set in the therapy already. She's had her intake. That was to keep moving forward.
And so I would ask the court to consider that the court still has that option available to it in terms of the remaining jail days. But I think it's more important for Ms. Watkins in a long-term state of life, because quite frankly, jail is not something that A, is rehabilitative, but B, is productive for her on a long-term basis. So I'd ask the court to consider that. However, if the court is considering jail time, I think 30 days would be far more appropriate than a 90-day recommendation.
Mr. Fanto, under any other circumstance, I would agree with you. I think I'm a pretty compassionate person, but the extent of this violation is absolutely appalling and egregious. And reason doesn't seem to work with Ms. Watkins. She was here yesterday because she drove into the court with a .05. And I mean, her defense was, well, it wasn't that far of a drive. I was courteous enough and kind enough, because she had a kid, to not immediately take her into custody. Instead, I advised her she could go pick her kid up from school, get the kid home, come up with her child home, come up with some alternative childcare arrangement so she could serve her few days on that violation. And I told her, if you don't come back tomorrow, you're going to get all the time. You're going to get all of it because it'll be your 4th violation. So she came back today. She drunk drove to the court while on probation. I mean, it's a .78. I mean,
I didn't drive today. I'm sorry.
Okay.
how'd you get here?
I got dropped off.
You came up to the court with a .78 the day after you just got in trouble for coming up to the court with a .05. So you literally 2 days in a row. And I don't know, I can't even begin to understand what you must have been thinking. And I think it's clear to all of us that you have a substance use problem, right? But I can't fix everybody if they don't want to be fixed. And after, yesterday you came out from sitting in the back for a couple hours and you had seen the light and you were going to behave and we weren't going to see you again. You were ready to follow the straight and narrow. And instead, not even 24 hours later, you came into the court drunk. I mean, it's so appalling to me that there's nothing else that's appropriate. 30 days is not appropriate. You're going to do 90 days with credit for the days you've served, terminate probation without improvement, and fines and costs will be waived.
And there it is, the breaking point. After back-to-back violations, including showing up to court intoxicated 2 days in a row, the judge finally draws the line. Watkins' probation is terminated, her fines and costs are waived, but she's handed 90 days in jail. The courtroom mood shifts from negotiation to finality. This wasn't just about poor judgment, it was about repeated disregard for court orders. What's striking here is how the judge balanced compassion, acknowledging her mental health and parenting struggles, with the harsh reality that safety and accountability come first. This case leaves us with big questions. Should courts lean more on treatment, or does jail become inevitable when probation fails again and again? What do you think? Was this sentence fair or too harsh? Let us know in the comments. And if you found this breakdown eye-opening, don't forget to like, share, and subscribe to Courtroom Chronicles for more raw, unfiltered courtroom drama.